This is the LWA Criminal Law Defenses Audio Outline. Defenses for criminal law include insanity, intoxication, both voluntary and involuntary, infancy, justification defenses, and exculpatory defenses. Insanity. There are 4 tests for insanity. 1. The McNaughton Rule. 2. The Irresistible Impulse Test. 3. The Durham Rule. And 4. The ALI MPC Substantial Capacity Test. Also address diminished capacity. You must address all 4 tests. The McNaughton Rule. The defendant is entitled to acquittal only if she had a mental disease or defect that caused her to either 1. Not know that her act would be wrong, or 2. Not understand the nature and quality of her actions. Irresistible Impulse Test. The defendant is entitled to acquittal only if, because of mental illness, she was unable to control her actions or conform her conduct to the law. The Durham Test. The defendant is entitled to acquittal if the crime was the product of his mental illness. This test is broad. But for the defendant's mental illness, the defendant would not have committed the criminal act. ALI or MPC Substantial Capacity Test. The defendant is entitled to acquittal if she had a mental disease or defect and, as a result, she lacked the substantial capacity to either 1. Appreciate the criminality of her conduct, or 2. Conform her conduct to the requirements of the law. This test represents the modern trend. Diminished capacity. The defendant may assert that as a result of a mental defect short of insanity, she did not have the mental state required to form the crime charged. Most states that allow this defense limit it to specific intent crimes. A few will allow it for general intent crimes as well. Only address if it is in the fact pattern. No cheating spouse provocation. Intoxication. Voluntary intoxication results from the intentional taking without duress of a substance known to be intoxicating. Defense to specific intent crimes only. Involuntary intoxication only results from taking an intoxicating substance without knowledge of its nature, under direct duress imposed by another, or pursuant to medical advice while unaware of its intoxicating effect. Does not apply to malice crimes. You must say it. Infancy. At common law, no liability for an act committed by a child under 7 years old. Between 7 and 14, reputable, presumptive that a child did not understand the wrongfulness of his act. Children over 14 are treated as adults at common law. Modernly, states have specific ages codified. Justification defenses. Although the defendant committed the proscribed act, society deems the defendant should not be punished because the circumstances justify the act. This is justification defenses. They include self-defense, defense of others, defense of a dwelling, crime prevention, necessity, and resisting arrest. Self-defense, non-deadly force. A person without fault may use such force as reasonably appears necessary to protect himself from imminent use of unlawful force upon herself. No duty to retreat. Deadly force, allowed if 1. Person is without fault, 2. The person is confronted with unlawful force, and 3. He is threatened with imminent death or great bodily harm. Generally, there is no duty to retreat before using deadly force, except under the minority view, and even then, there are 3 exceptions. Defense of others. The defendant has a right to defend others if she reasonably believes the person assisted has the right to use force in her own defense. All that is necessary is the reasonable appearance of the right to use force. Defense of dwelling. Non-deadly force may be used to prevent or terminate what is reasonably regarded as an unlawful entry into or attack on the defender's dwelling. Deadly force can only be used to prevent a violent attack made with intent to attack inhabitant or to protect an entry to commit a felony. Note on the exam, deadly force is justified to repel an invader, but the basis must be to protect the safety of the inhabitants inside, not to protect the dwelling. Crime prevention. Non-deadly force may be used to the extent that it reasonably appears necessary to prevent a felony or serious breach of the peace. Deadly force may be used only to terminate or prevent a dangerous felony involving risk to human life. Resisting arrest. Non-deadly force may be used to resist an improper arrest, even if a known officer is making the arrest. Deadly force may be used, however, only if the person did not know that the person arresting him was a police officer. Necessity. Defense to a crime that the person reasonably believed that the commission of the crime was necessary to avoid an imminent and greater injury to society than that involved in the crime. Note, this is a utility test. It is not just necessary, but a worse result would happen to society, not just the defendant, if the defendant didn't act in a criminal manner. Necessity limitations. Death. Causing the death of another person to protect property is never justified. Fault. Not available if the defendant is at fault in creating the situation requiring he choose between the two evils. Distinguished from duress. Necessity involves pressure from natural or physical forces. Other defenses include duress, mistake of fact, consent, and entrapment. Duress, not a defense to homicide. The defendant reasonably believed that another person would imminently inflict death or great bodily injury on him if he did not commit the crime. Mistake of fact could also be ignorance of fact. Relevant if it shows that the defendant did not possess the requisite state of mind for the crime charge. Reasonableness of mistake is key. For malice crimes and general intent crimes, reasonable mistake of fact. For specific intent crimes, reasonable mistake of fact and unreasonable mistake of fact. Mistake or ignorance of the law. General rule, no defense. Some exceptions, reasonable reliance on a statute or judicial decision, and also reasonable reliance on official interpretation of advice. Consent, typically not a defense unless the crime requires a lack of consent by the victim. Required: 1. Voluntary and freely given. 2. The party was legally capable of consent. And 3. No fraud was involved in obtaining the consent. Entrapment exists only if 1. Criminal design originated with law enforcement, and 2. The defendant was not predisposed to commit the crime prior to contact by the government. Merely providing an opportunity for a predisposed person to commit a crime is not entrapment. That ends our criminal law defenses audio outline.